Hello students, today's topic is Estable section 115 to 117. We can call doctrine of Estable. Definition of this word, section 115. It says, when one person has by his declaration, act or omission intentionally caused or permitted another person to believe a thing to be true and to act upon such belief, neither he nor his representatives shall be allowed in any suit or proceeding to deny the truth of that thing. You know, we make statements, every human being makes statements in our life. Some statements may be statement of truth. Some other statement may be statement of falsity. This section 115 says, whenever a person makes a statement to another person, whenever a person makes a statement to another person, and the statement is made to create a belief in the mind of another person, and that another person believes in the statement of the first person and acts upon it, change his position, invest the money, then subsequently the one who made the statement, he will say, no, I am not bound by it. I don't want to yield to you. I don't want to agree and to obey the talks between you and me. So the law says here, section 115 says, stop. Hey, you will be stopped from going back on your words. Whatever statement or words that you have made, you are bound by it. We will not allow you to take back your statement, because the other person has believed in your statement, he has acted and he has altered his position. Come on, you stick to your position. In simple words, when a person makes a statement, whether it may be false or true, he is bound to obey his own statement. He will not be allowed to deny that statement. This is called Estable. This statement may be oral, or by means of conduct, or by means of a document. Whatever it may be, he is bound to obey the statement, even though it is false. Remember, in the exam, as a student, they may ask you the question, what is the doctrine of Estable? Explain the kinds of Estable. This is the question. What is the doctrine of Estable? And explain the kinds of Estable. So remember, section 115, the definition. See, in answering keep the names of the cases. Law of evidence needs cases and illustrations if you want to pass in the exam. So remember this case, Pickard versus Sears, 1837. Okay, by heart this, Pickard versus Sears, 1837. You know, in this case, one Mr. A intentionally, falsely misled to Mr. B. One Mr. A intentionally, falsely misled Mr. B. He made Mr. B to believe that A is the owner of certain land. A is not the owner of land, but he made a statement that I am the owner of land, and Mr. B believed in it. And thereby Mr. A and B entered into an agreement. What is that agreement? Agreement to sale. Agreement to sale. So there is a time limit. Now Mr. B has paid certain amount of money in advance, saying I will pay the rest of that money, and then we will go for registration of the document. Mr. A received the money. During the period of this agreement, Mr. A automatically became the owner of that property. He became the owner. Now, Mr. B is ready with the complete money. He comes forward and say, come on sir, we will go for registration. I am ready with the money. But A says, no sir, I don't want to sell this property because at that time I was not the owner. I fraudulently I made a representation to you, and now I don't want to sell. So Mr. B went to the court and presented the petition to execute specifically the agreement to sale. And the court ordered Mr. A, you have made a statement. You have made a statement purposefully to make Mr. B to believe that Mr. A is the owner of the property. Mr. A, now you are the absolute owner of the property. Now we will never allow you to go back on your statement. You are bound to obey your statement. Come on, sell the property to Mr. B as per the agreement. Right? So, Mr. A was stopped from going back on his own statement. Okay, friends. Now, see, I would like to give some of the cases. Shrikrishna versus Kurukshetra University, 1976. This is the case of an LLB student. You know, LLB examination is approaching, and this fellow was given the form, examination form, to fill it up. There are so many columns. He has filled all the columns, but he failed to fill up one column, that is the attendance column. He left it like that. He submitted the form to the university. The university accepted the form. There is a failure to notice that attendance column, and he was given the admission ticket. He took the admission ticket. He wrote the examination. The examinations are over. Afterwards, he secured very good marks and he continued on the basis. He joined the higher courses. Now the question here is, finally the university discovered that there is a shortage of attendance by this candidate. Now they want to withdraw the certificate, marks cards, everything, the degree certificate, everything, saying you have shortage of attendance. Good. Now he filed a case against university. You know Kurukshetra, on the way to Punjab, in Haryana, you can find this university. The case came up before the Supreme Court of India, and the court analyzed the doctrine of Estable. University has made a statement. What is that? They have given him the admission ticket, saying that you have all the qualifications to write the examination. On the basis, he wrote the exam, got cleared, and took up the next step. So now the university wants to withdraw his candidature. And the Supreme Court said, no, you have given the admission ticket. Now he has accepted it. He has changed his position now. We don't allow the university to withdraw the candidature under the doctrine of Estable. Another university, another case, Nabha Kishore versus Utkal University, 1978. See here, Nabha Kishore, you know, all of us, when you in the write the exam, you will think, I will get only the minimum marks. But sometimes, unexpectedly, you will get 80 marks, 90 marks, like that. What you will do? Psychology. What kind of psychology we have? When we were expecting only the minimum marks, when we get the very good marks, then you know, we will keep quiet. Or we will give a picture that I am intelligent, I have written so beautifully, wonderfully, that's why I got this big marks. In this case, same thing happened. Same thing happened. This fellow has wrote the exam and he got he has not written well. He was expecting a very low marks. Fortunately, the university has given a very high distinction. Highest marks was given to him. This fellow received the marks. On the basis of the marks, he applied for the master's degree. He joined the master's degree. He paid the money to the master's degree on the basis of the marks card given by the university. Then afterwards, the university discovered the miscalculations. Now they want to withdraw the marks cards and the degree certificate. He filed a petition to stop the university. And the court said, you, the university, it is your failure, it is your carelessness, it is your negligence. Now you have given the marks cards. Now we don't allow you to withdraw the marks card. Now we don't allow you to deny the marks card. It is a statement that you are bound to obey it. Right? Right? Okay. Then we will go to the most important case in the doctrine of Estable. Motilal Padampat Sugar Mills versus State of Uttar Pradesh, 1979. India needs economy, not the politics. Economy should not be destroyed. The government must have policy for the development of economy. So in this case, the government of Uttar Pradesh made an announcement, encouraged the new people to commence industries, to commence factories. The government announced that whoever going to commence the new industry, we the government of UP, we will not impose sales tax continuously for a period of 3 years. We are not going to impose any tax. One Mr. A, he saw the advertisement, he approached the minister, he approached the secretary, he approached the top officers of the government to confirm whether there is a scheme of exemption of sales tax for the new industry. All the minister, all the officers have told with 100% confirmation that our government supports new industry. We want employment. So we are not going to impose any kind of sales tax for 3 years. So Mr. A, satisfied with the assurances of the ministers and the officers, and he started a new sugar mill industry. But within few months, from the commencement of this industry, the government went back on its word. It has imposed the sales tax. So this act of the government was challenged, and the court held, yes, the government is stopped from going back on its word. The government don't have the power to impose sales tax on the new industry because they have made a promise. It is a promissory estoppel, and the government is bound by its promise. Right? Yes. Let us go to the next case. Suresh Pal versus State of Haryana, 1987. You know, nowadays, whenever you want to join an institution, you must see the board of that institution. There you will see recognized by the Bar Council of India, recognized by the government of Karnataka, recognized by the government of Uttar Pradesh, recognized by the UGC. So many things you will find on the board. That means it is an assurance to the future students whether this institution is having the legality for the students to join or not to join. When all these recognition boards are there, and the student will join without any fear that his fees will be safe, his course will be safe. So in this case, Suresh Pal's case, Suresh Pal joined a physical education institute. before joining he had seen that board, that approved by the government of Haryana. He has joined that course. Suddenly, in the middle of the academic year, the government has withdrawn the recognition. And immediately the students have challenged the act of the government as illegal. So the matter came before the court. And the court said, you the government, you cannot withdraw in the middle of the academic year. If you want to withdraw, it will be applicable for the next academic year. Okay, you can withdraw the recognition in the next year, next academic year, and it should be notified to the people so that the fresh students will not join the institution. And it said, you the government, you cannot withdraw. You are stopped from withdrawing the recognition for this academic year. So the court has protected the lives of, careers of all the students who have joined that institute. Okay friends, so write these cases minimum. Now the question next is, explain the kinds of Estable. The first one called promissory Estable. Promissory Estable. Okay, underline this. And you know, when one person makes a promise that I am going to give this benefit, I am going to do this act for you, okay, then the other person believes on the promise and acts on that. Which example out of these cases, which one you have to write here? Promissory Estable. Please write Motilal Padampat Sugar Mills versus State of Uttar Pradesh, 1979. The promise of State of Uttar Pradesh for the new industries not to impose sales tax for 3 years. It is a promise of benefit. Okay, it is a promissory Estable by the government. Kindly write this one. Now we will go to the second one. Estable by record. What is this record? Record means anyone who comes to the court, stand in the witness box and make a declaration, make a statement, then he is bound to obey that statement. It may be a false statement, it may be a true statement. He will not be allowed to deny that statement. So any declaration made in the records of the court is called Estable by record. Now, one illustration I would like to give you. Consider there are 4 brothers in a family. There is ancestral property in the family. 4 brothers, ancestral property. There are also loans on this property. Okay, 4 brothers, ancestral property, loans. Now you tell me, who has to clear the loan? Is it 1 brother or 2 brothers or all the brothers? All the brothers have the duty to clear the loan. Is it not? Now, consider one creditor has filed a case against all these brothers. All the brothers came to the court. All the brother, 4 brothers came to the court. Then one brother, let me say the last one, younger brother, He submitted a statement to the court saying as follows: I don't belong to this family. See the words. I do not belong to this family. I don't have any right on the property of this family. Nobody can compel me to share the loans of this family. So, kindly excuse me, relieve me from this pain of sharing the loan. This was recorded.